Good morning, everybody. I assume I'm using this here.
Yes.
You had to put it in my bra and whatever. I wasn't planning on undressing when I left home today. I think I've already, as it were, broken the tension because everybody sounds like they're free and they're laughing, etc. But I have found the other icebreaker for me that takes the cup is to tell everybody in the room that I'm not related to the mayor. I'm not related to Masondo. I'm not related to the General Masondo. I'm not related to any of those people. Because if you're like me, you walk into a room and you hear Mutsipe, you're thinking, he's related to Patrice. So in my case, no, I'm not related to any of those people. So let's just move on into who I am. I'm here, I'm Happy Masondo, and no relations to all the political people, etc. So today, I must just thank Delia in particular and the team for inviting me to come through here to provide this masterclass. I'm hoping that it is beneficial. I don't want to whine about things and complain, but it did take me a few hours to put it together for free. So. Well, that said, so the topic of discussion today is fiduciary duties and the duty of care in particular. And Delia was quite concerned that I focus on specific provisions of the Companies Act, which was quite helpful, actually.
Slow down a bit, sorry.
Oh.
Sorry.
Okay, no worries. Where do I go back to the beginning?
No. Slow down a bit.
Okay,
thanks.
All right. That's going to be hard, actually. Yeah. Remember, I get paid per word, so the more words I speak, the higher the amount. Okay, so responsibilities.
So I think
okay.
you should be able to cover.
Yeah, responsibilities of directors as envisaged in 75, 76, and 77. I tried to bring out, so when you read, even as a lawyer, I'm finding the Companies Act quite dry. If any of you are readers, it's quite dry and it's laborious and it's quite boring to read. But when you sort of bring it to life and you, for one, provide life experiences or things that you've seen yourself and so on, I think it brings it to life a little bit and makes it a little bit more exciting than it actually is. I guess laws were never meant to be exciting. You're supposed to know what they are and then try and apply it to particular circumstances. So, so in relation to the duties of individual directors, as I am, or collectively when you're sitting as members of the board, have significant legal responsibilities and obligations. These responsibilities and obligations are so paramount that they can also be held personally liable. So as a director, I could be held personally liable if I breach or fail to comply with the duties dealt with in the statutory provisions of the Companies Act. In general, when you take the discussion out of this room and you just think about what has happened in the world, we've seen throughout the world where there's been untold suffering resulting from the experiences of massive corporate scandals, such as Steinhoff in our case, Enron, WorldCom, the subprime mortgage crisis. I mean, there are many. You can think of them in the last even 20 years, just how many there have been of those. So following all of these crises over the years, and at the time that our own Companies Act, the new Companies Act came into being, these crises have been a rise in public interest in good corporate governance, proper diligence, and reasonable management of companies. So in this presentation, I try and touch on some of the statutory provisions, specifically 75, 76, 77. I suggest that you read them at your leisure when you can. And so I try and say, for me, what resonates and what has always resonated over the years when I've sat on boards is what is in the best interest of the company. Now, you see that that phrase, what is in the best interest of the company, also embedded in the provisions that we're going to deal with. But before we get into the details of those, I say again, when you ask yourself, what are the legal duties? What are the director duties that we're talking about? We are talking about legal responsibilities that are imposed by the law. So, it's not like random stuff where I decide, oh, today this is my duty, tomorrow this is my duty. Actually, the law prescribes to you what those duties are. And I've divided them into two parts. The first part, which will probably have more of the details, would be the fiduciary duties. And the second part, which I deal with later, are your statutory duties, okay? So in our law, fiduciary duties are the highest duties and legal obligations that directors owe to the company and its stakeholders. You must remember the company in our company laws is treated as a separate juristic person. So when the reference is made to the duties you owe to the company on whose board you sit, you're talking about a separate legal entity from yourself and your fellow board members. So in general terms, the legal obligations that we talk of you are required to act in good faith and in the best interest of the company. And historically, these concepts have always been part of our common law. Common law in the past, before we had Roman Dutch law and so on, were the laws that were not written as such. People did out of practice. But all of these legal principles have now become entrenched in our statutory provisions, in particular right now in the Companies Act, but in all other statutes. So as you will note from the speaking notes, while I make reference to specific provisions of the Companies Act, I have also tried to connect the legal provisions to case law that we've seen, we've witnessed, we've heard in the news, we've read the newspapers. And not to be nasty or anything, but my favorite case that relates to a director who acted in the best interest of everybody else except the company is the outer case against Dudumien. I'll get into it at a later stage, but that was very public. We all got to know about it. There were many, when we started, there were many cross applications, et cetera, et cetera. So we'll get into that. Let's just go into detail then about the breakdown that I've done in relation to the fiduciary duties. The first one, as part of that globular term of fiduciary duties, is the duty of good faith. Now, when you read duty of good faith, you're asking yourself, I wonder what that means. And why would the legislature draft a provision that says you have a duty of good faith? We see it in contracts, those that draft contracts, we see that clause a lot, and there's a clause of good faith in the contract. So it does go through, it permeates all manner of things in our laws. So you carry the fiduciary duty to act honestly at all times, in good faith, and for a proper purpose. So you are in a company, the first thing that occurs in your mind is you can't lie about why you are taking a particular action. It's probably a wild example, but you can't take a decision in connection with a company to go and sell drugs, for instance. I'm using very crappy examples, but you get what I mean. So that for you, if you take a decision for a company to go and sell drugs, I'm talking about proper drugs like meth and tech, not like Discam sells drugs, not those drugs. So it wouldn't be for a proper purpose. So that's section 76(3)(a) that says you are obliged as a director to act honestly, in good faith, and for a proper purpose. If you want to go and read a little bit more, you can have a look at the case of Langen and another. It's a 2022-2023 judgment of the Gauteng High Court. And amongst other things that were said in that judgment, the court said the fiduciary duty which a director owes to his or her company is a cornerstone of our company law. So one moment you might think the duty to act or duty of good faith, it couldn't possibly mean too much more than what good faith is. But you have to go into the decisions of the court where they talk about you can't sort of take it lightly. If the court decides that it's a cornerstone of our company law, then it means you must take it that seriously. So you often find that when you get into companies, when you get invited to go and sit on the board of directors, often people take you probably for, maybe they know you, maybe you've acquired qualifications from, I don't know, Harvard, maybe you've done training with the IOD, for instance, all of those things. And they assume that you know what it means to act in the best interest of the company, or you know what it means to have a duty of care, because there's an underlying assumption that, well, they are the director, they know what they're doing. But I constantly remind myself, why am I on this board? And it's never about, who I know. It's never about the chairperson. It's never about who invited me on the board. It's never about I went to high school with them. It's never about that. I constantly have a discussion with myself about why am I here? And when I go through the steps of answering the question to myself, I always ask, am I carrying out the duty of good faith in the manner that is expected of me? Am I acting honestly? Am I executing any of these decisions for a proper purpose? So have a look at section 76(3)(a) of the Companies Act, which deals with the duty of good faith. And if you're bored, also have a look at the decision of Langen. There are lawyers amongst us who just read case law for fun, but they're not fun. They're quite actually dry and drab. The next element of the fiduciary duty is the duty of loyalty. Now, loyalty, we are talking about not loyalty to the person. I have had experience where I'm invited by, say, the deputy chairperson of the board, or even the chairperson of the board, to sit on a particular board. And I think there is an underlying expectation that, I brought her on this board, she's going to be loyal to me, type of thing. And without breaching confidentialities, I had a rude awakening for one of the people that I had been on a board with. They invited me to the board. They called me, would you like to come? And then I went to the interview, blah, 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 blah. And then there was a connected person, a transaction that was going to happen. And they happened to be one of the parties that was going to be in the transaction. So a connected transaction, it's where members of the board and or executive team members are interested in the transaction that's about to happen. So, the entity was going to buy into another company, and these individuals were also going to get 2%, 1%, and whatnot. So those of us on the board that were not interested in the matter, were then, we convened a meeting at which we're going to discuss, is this transaction good for the company? So then at the beginning of the meeting, the company secretary comes and they open the meeting, and then they set out the declarations, so-and-so is conflicted, so they are not here. So-and-so is conflicted, they are not here. So-and-so is conflicted, they are not here. Then I'm going to use Chloe as an example because I know her. And then Chloe is in the room. So then I say, but wait, so Chloe, don't you also have 2% interest in this? Chloe says, yeah, I do. So I say, so what are you doing here? And remember, Chloe is a person that invited me to the board, or introduced me to the board. So Chloe now is embarrassed because there's no explanation for why she's in the room. You've told us about 4 people, including Chloe, excuse me, who are conflicted, but Chloe is in the room. So I'm confused. I honestly was confused. I didn't know what she was doing in the room. So then I said, so why are you here, Chloe? And she goes, well, I just thought that I should come in and give a background on this. I said, but that's why we have the CEO and the CFO. The CEO is going to tell us, what the transaction is about, why it benefits the company. The CFO is going to tell us if we can afford it. So I still don't understand why you are here. So I still don't understand today why Chloe was in the room. But then she eventually left the room, right? She eventually left the room, and then funny story, right? But true story. the colleagues that were there kept on sending me WhatsApp. Yeah, you're right. You're right. Yeah. But I was asking myself, so why didn't you say so, right? You know, so it doesn't help any of us, particularly the company that you are representing, to be receiving these messages of support underneath the desk, as it were, when in fact you could have all said, yeah, no, yeah, actually, why are you here? So that everybody knows how you feel about it, as opposed to only feeling like I'm being personal, right? Anyway, this is a very practical example of what has happened to me. I'm not talking about other people. I'm talking about me personally. And this happened, thank goodness, I haven't been able to sort of mistakenly drop a name, but it happened on one of the boards that I currently sit on. So then, thereafter, just to finish the story, there was a little bit of tension between myself and Oli. You could say, I think she probably was thinking, damn it, man, this woman, I shouldn't have invited her or whatever. But I think once she had sort of applied her mind to what was going on in my own head, she sort of, I think, came to realize that it was not personal. But you can have that type of conflict amongst colleagues in these situations. Anyway, so my loyalty on that day was me executing my fiduciary duty to act in the best interest of the company. And I wasn't concerned about, them. I wasn't concerned about Oli. I was just concerned about, does it serve the company in the end? And in addition to that, in terms of Section 73B, you have to avoid conflicts of interest. And that's what I was trying to do on that day. I was trying to say to Oli, you are jeopardizing your own position by not avoiding this conflict of interest right now, because you are an interested party in the transaction. So why are you sitting in the room? And then at the same time, because also Oli was, if you like, senior to me, and I think most of the board members, if I recall well, senior as in the number of years that they've been on the board. They are the chairperson of REMCO, chairperson of audit, and they're the deputy chairperson. They're like the lead independent director. So I said, you're jeopardizing your own position, and therefore, people are going to then question whether, you are in fact executing the fiduciary duty. So it was a bit of a spat in there. But in retrospect, I think we are quite grateful that I raised that sting about it. And I've cited, to support the provisions of Section 76(3)(b), I've cited the case of Fisheries. And in that case, the court emphasized that, when you comply with the provisions of 76 in particular, 76A, 76(3)(a), B, and C, you are unlikely to ever be found to have acted unlawfully, because it sets out all the steps that you have to take to ensure that you act appropriately. All you have to do is just execute the fiduciary duties that the Company Act imposes on you. So, and the court in that case said circumstances where directors would be found to have acted unlawfully could be very rare, especially where directors exercise their powers in good faith for a proper purpose in the best interest of the company. So we've seen that already in the provision that I've been speaking to. Now, when you act for a proper purpose, it cannot be a subjective inquiry. You can't say, no, it's a proper purpose because then I get to go to dinner with the chairperson of the board, for instance. I can't think of proper examples, but it cannot be that. It should be objective. So when I say it's a proper purpose, the next person would be able to say, yeah, no, absolutely, objectively speaking, it's a proper purpose. So would a reasonable person in your position take the same decision that you've taken to show that it's for a proper purpose, right? And if you go through that inquiry for yourself as a member of the board and you come out with the correct answer that says, yeah, this is for a proper purpose, you're unlikely to go wrong. And then the third part of the duty, the fiduciary duty, is the duty of care. And inside the concept of duty of care, you have a fiduciary duty to exercise reasonable care, skill, and diligence in carrying out your duties as a director. So where the reasonable care, I already spoke about it previously, but skill, it's talking about what skill you have. And you will realize that how boards are constituted typically, they look for different skills in different people. So for the most part on the boards that I sit, I'm the only lawyer. So you find an accountant, depending on the industry, you find an IT expert, et cetera, et cetera. That skill is what you have to exercise and bring to bear when you're sitting on the board and you're opining on the functions of the board. And diligence is really just making sure that the decision that you're about to make or have made, or you have to apply your mind to, that decision has been considered diligently by all of you. It's like doing, a due diligence. Like a proper due diligence as we do in law, but it's diligence in anything. If you're moving into a new neighborhood, for instance, you go around there, you drive around, where are the shops, where are the schools, et cetera, et cetera. That's really in practical terms what diligence is all about. I've cited in there the case, the Fisheries Development Corporation case, which, excuse me, which the court considered to be an authoritative decision on the duty of care. And in that decision, the court stated that courts understand that non-executive directors are not operational. You're not there day to day. You rock up once every quarter, if that. So while you are going to be absolutely reliant on the executive team, your CFO, your CEO, your CMO, all of those people to provide you with information, this duty of care does not exonerate you from applying your own mind and actually thinking about things, applying your own skill, applying your own independence, and so on. You can gather that information from all of these people, from your board pack, when you read your board pack, and ultimately, CFOs, CEOs, they might point in the direction in which they want your decision to go. But ultimately, the final decision that you make lies with you. And that's a duty of care. So I mentioned earlier on, I had a flu a week ago, so my voice is still hankering, going back to the flu virus that I had. It keeps coming and going. So what I did now, after we've dealt with 76, in particular 76A, B, and C already. And I mentioned to you that there are certain principles that we find in our law, which were common law principles, which have now been codified in our legislation. So now it has left it to people not to have any doubts about what it means. So you can't be confused and say, it's an old law, it was a common law, you know what the statute says in terms of the current Companies Act. A similar provision that has also been codified in our law is the so-called business judgment rule. The courts have referred to it as a business judgment rule. And that you find in section 76(4). You can read up on section 74 in the Companies Act. And in fact, I have found out when I have, I think, accidentally read cases from elsewhere in the world, the same principles has been codified in their own company laws. So this rule, in terms of section 76(4), where you are seized with a decision as a director of a company, you can never be said to have gone wrong or have exercised your judgment incorrectly if you have satisfied your legal obligations in terms of section 76(3)(b). We've talked about it earlier. Section 76(3)(c), we've talked about that. And the provision says, if a director has taken reasonably diligent steps to become informed about the matter, you remember I said you read your pack, you speak to the CFO, CEO, either the director had no personal material financial interest, like Oli had in the other case that I was as an example, and you had no reasonable basis to know that any other related party within the board had a financial interest, or you've complied with the provisions of section 75. Now, I know I haven't spoken about 75 years, but 75 is a very broad clause that tells you to whom the duties, the fiduciary duties apply. They include directors, they include prescribed officers. So certain people might not even be part of the board, like prescribed officers. Sometimes they're not members of the board, but section 75 applies to them. And that applies to them in relation to the duty to disclose. You have a financial interest, you have to disclose it. And the director made a decision on a rational basis. So rational, reasonable, with diligence, with skill, those terms are all related. And if you do a proper analysis of Section 76.4, it's really a way in which I think our courts, but also the legislature, the people that wrote the law, are trying to guide directors to say, you know, you do these things, you are unlikely to go wrong, you know, unlike the late Duduye, you know, when your focus is on everybody else, I mean, she literally wanted to benefit everybody else but the company in the decisions that she was taking, you know? And I mean, you know, some of you might argue she didn't know, which I think it's a low threshold. Not to know is a very, very low threshold. But as we know in our criminal law, ignorance of the law is no excuse. So you can't say, I did not know. It's not an excuse. So the business judgment rule, and we're talking about Section 76.4, when you get time, you can read in. It consists of a rebuttable presumption. Everybody knows that sounds like big English, but it's actually not big English. Rebuttable presumption, it's you are presumed to have made your decision on an informed basis, in good faith, and in the honest belief that the action that you have taken is in the best interest of the company. And they use rebuttable just to say, if those elements that I have mentioned here, and let me repeat them, you have acted on an informed basis, in good faith, in the honest belief that the decision was taken in the best interest of the company. So you assume to have done, you assume to have taken your decision on that basis, but it can be rebutted. So it means you can contradict it by showing that, no, this one only in my case, in my example, was trying to do something that was not really in the best interest of the company. And I think, I think back most of the time about that day, and it may have been an innocent thing, and maybe it may have been, no, I just want to sort of talk to it because all of you are too dumb to understand it, or something. I don't know. It may have been an innocent thing, but it wasn't innocent in my eyes as a person who wasn't conflicted. So I know that in the beginning I mentioned the issue of the responsibilities and the duties that directors have are so paramount that if you don't comply with them, then you are likely to be personally liable. You can't hide behind a fiction of, oh, I did it as a director. You can be personally held liable. But also I'm talking about Section 76.3, A, B, and C. I've spoken about Section 76.4. Those provisions are what we call safe harbor. So you're in a safe space as a director to say, you know, I'm protected by these provisions of the law in order for me to execute my duties properly as an upstanding director. So shall I move on to then the other part of your fiduciary duties? So you have fiduciary duties that I spoke about, and I broke them down for you. And then we go into statutory duties very quickly. Those are the legal obligations that directors have under South African law. So just because the company law says these are the things that you have to do in order for you to be an upstanding director, it doesn't mean you can ignore the Constitution, for instance. Okay, so when you're talking about statutory duties, we're talking about specific laws of the land, all the other laws of the land. You must comply with the financial reporting, for instance. So I'm not an accountant, and I don't claim to be an accountant. So when I sit in a board meeting, I'm relying on the accountants in the room, the CFO, all those people that deal with the numbers to tell me what the status of the company is. But as a responsible director, I also must ensure that the financial statements comply with legal requirements and provide true and fair view of the company's financial position. So I have to satisfy myself that. So if I don't understand things, I'll sit with the CFO and say, I don't understand this. I don't, and you know, accountants, there's some in the room. You're always talking about fictions and it's a journal entry, it's crazy. They always say all these things that make no sense to me. Having done accounting, by the way, in high school, but it just goes over my head. So If it means that you must spend hours with the CFO to explain the fiction, and it's a journal entry, it's not a real thing, and depreciation, provisioning, just, just say to them, speak to me like I'm a 4-year-old. I want to understand this properly. And that's your obligation to do. And if you don't understand it, you're not going to vote for that decision. Just make it clear. I don't understand it, forget it, I'm not voting for it. And that puts an obligation on them to dumb it down for you because you're not an accountant and they tell you what it means. In addition, you have to identify and manage the risks that the company could have, that could affect the company's business operations. And for me, the early example was a proper risk, because shareholders would have said how Oli was sitting in the room in a transaction, trying to convince the rest of the board to vote for the transaction. It's hot, ne? Yeah, I thought so. It's blowing hot air. It's blowing hot air, actually. I hope I'm not blowing hot air. So you have to manage the risk that the company could potentially face, and the things that can affect the company's business operations. Okay. So I don't know how the structure is. Do we pause for questions, or do I just keep going until the end and then wait for questions later? I keep going.
Can you hear me? Yeah, great. There is one question from online. Are there similarities between directors' duties or the duties or responsibilities of trustees and directors?
Same. Same.
You on?
Yeah. Oh, same. Yeah, it's the same. Trustees, I think in your reading what I've done for the last 30 years, you picked up that I also sit on the trust of the Entrepreneurship Development Trust. The verse, chapter and verse of the Companies Act applies exactly to trustees as well. Yeah.
Great. Thanks.
Yeah.
Are there any other questions in the room? Yes.
Thank you. Hi, I'm Shanila. So a lot of what the board does, it depends on information that you get from the CFO and the CEO.
Mm-hmm.
And, this personal capacity liability, how is the CEO also culpable, should something go wrong? Is there personal liability aspect to the CEO as well?
Yeah.
And the CFO?
Yeah. So we can I go on? Yeah. We typically on boards, we have non-executive directors. I'd be one of those people. So people that are not involved at all in the operations of the business, and they come once every quarter, if that. Maybe they come for special meetings, or maybe they come in for committee meetings, etc. But your CFO, the C-suite people typically are also members of the board. Your CFO, your CMO, your CEO, those people. And they carry absolutely the same liability. Yeah. Okay. Can I proceed? Okay. So now.
There's one more question.
Yeah.
Are we running out of time?
No, we're not. Yeah.
Okay, the question online from Ophelia. Directors are often afraid to lose their positions by dissenting. Your advice, please, on a safe and effective way to dissent.
The law is actually fantastic in that way. There's some people, and you're right, and I suspect those people, and I love that example with Oli, because there were about, 6 other directors other than the 4 that were not in the meeting. That the 3 that had been excused because of the conflict, and we went Oli in the room. So there were 6 other people in the room who could have said the same thing that I said, but they didn't, right? And precisely because maybe some people thought, oh, maybe I'll lose my position on the board, or maybe this or that, or maybe, So when you vote, typically when you vote for a decision, there is for, I vote for, I agree. There is against, you vote against, and typically it's anonymous, when you provide it when you have to vote, or you abstain, completely abstain. You're like, there's a for, against, abstain. So you tick abstain. I'm not doing, you're sitting on the fence. I'm not saying yes or no. either way. Absolutely can do that. I have been in situations where I have said, well, you know what, if you disagree with the decision, very quickly, another very quick example, we had made a decision some 4 or 5 months prior that this is the way the company was going to go because we thought that it meets the objective of the company, it goes along with the strategy of the company. And then out of the blue, we wake up one day and the deputy chairperson calls people individually to say, no, we have to change that decision. So then an urgent meeting is called and we go to walk into the room and they're like, no, you know that decision. So I said, so what's changed? We sat here, we all agreed that this is the decision that we must take. 5 months later, there is this urgency that people are calling. What's changed? No, I can't get into those facts because you'll probably know which company I'm talking about. But it was, no, whatever. So then I said, well, actually, I don't mind to leave this board if it means that a decision is going to be taken to favor you just because you are Shani or because you are Toli. I'm happy to leave because I don't want my name to be associated with, that wrong decision, what I believe to be a wrong decision. So you can also do that. But, I can understand perfectly when people are anxious about, I might lose my position. But quite frankly, speaking for myself, my reputation is more important than what position I hold because that's all I have. And I take myself with me. Everywhere I go, I take myself with you. I have a 20-year-old son. He's about to turn 21 in July. And he's always calling me about girlfriend's problem. Mommy, is it fine to do this or not to do this? Can I lead on a girl? And my answer, sometimes I don't know why he's saying these things to me, but sometimes my bottom line is always, you take yourself with you, my boy. You make that decision today. In 5 years' time, you will still be there with yourself to live with that decision. And it resonates with him quite a bit. I think Delia has given me a stare of death.
I wanted to ask you a question.
Oh, okay, please go ahead.
Around the reasonable men test.
Yeah.
So it's I think most cases will say that you have to, so the courts will look at what a reasonable man would have done in similar circumstances, right?
Correct.
So that would be in relation to the 76.4?
Yeah. In our case, it would be all of those provisions,
yes.
76.3, 76.4. And, in these provisions, they talk more about, let me just go back, acting rationally. Your director had a rational basis for taking a decision. Reasonableness is associated with rationality. And when you're talking about, and it's unfortunate, our law usually uses reasonable men, but it's also reasonable women. But you are actually being asked to have an inquiry with yourself. Would a reasonable person in my position have taken the same decision? So Oli's example, for instance, the other 3 people were quite happy to not be part of the meeting. They recused themselves. They didn't even attend the meeting. The company secretary declared immediately, these 3 people are not here because they are conflicted. That one has 5%, that one has 3%, etc. She's sitting in the room. Her colleagues with whom they've been trying to get this transaction together are not there. She's sitting in the room. There was so much unreasonableness and irrationality in Oli being in the room. And to say, I wanted to give you background was not good enough for our purposes. Because, when you're sitting in the room and you have an interest in a transaction, and then there are people that are sort of beholden to you. They respect you, you're senior, you are an achieved business person and so on. They influence the tenor of the room. The conditions in the room and, which way debate should go. Some people are shy to say something because you're sitting in the room. So that decision in particular was not what a reasonable person would have done. In fact, the other 3 who recused themselves and didn't show up at all acted like reasonable people. So you really apply the standard. You don't apply what you think personally. You're thinking about, there are 5 of us that are reasonable people. Would we act the same way as reasonable people?
How do you proactively deal with conflict of interest where you've got shareholders around the room who are also directors.
Yeah.
So for example, if you are considering an M&A transaction, they are interested in, the share value must go up.
Yeah.
You are worried about all the other stakeholders and the community and so on, the impact that this deal will have on all stakeholders.
Yeah.
How do you balance that? What do you do?
No, that's actually very exciting because that's a part that I wanted to get into now. If you use the test and you find it in section 76, you find it in section 75, what is in the best interest of the company? That's your North Star. I can understand that you are worried about all these other interests. But when I go into my discussion in this paper, I hope they will share this paper with other people. What is in the best interest of the company? Your North Star, everything else falls away. Your North Star, when you're considering interest, is your own interests, okay, are irrelevant. The interests of the C-suite, the CFO, CMO, CEO, all of those people are irrelevant. The interests of your friends around the board, I go to a house for tea, she bought me a nice bag. Those interests are out the door. That's not your focus. The interests of the chairperson of the board, because maybe other people are beholden, they like the chairperson or whatever. Those interests are irrelevant. The interests of the shareholders, out the door. The interests of other stakeholders, as you correctly say, Dee. Those are not things that are paramount when you are making the decision in relation to the company. All the time, when you wake up in the morning, you're a board member, you're asking your same question every day. What is in the best interest of the company? When you have answered that question for yourself, you will see how that then sort of goes down to support your stakeholders, support the shareholders, or whatever it may be. But your cardinal point, you don't have to be, I don't know what to do. You don't have to go through that. Once you've answered the question, is this in the best interest of the company? Ask yourself, what is in the best interest of the company? And when you then come down and you're making your decision, you're talking about, am I acting in good faith? Am I being loyal to the business, to the company? Am I executing all of my fiduciary duties? Have I complied with all my statutory duties? When you answer those questions, the best interest of the company has to always come tops. Yeah, there should never ever be a conflict. I know that we get conflicted a lot because the shareholders are on our back. The share is not performing, blah, 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 blah. And then the stakeholders, this one is Mr. Company. He owns this business. I can't say anything against him. That's not what you use in your inquiry, And it's possible, in our example of the outer case, that the late Dudu was thinking about all of those other people, He was thinking about Department of Trade and Industry, whoever that department is that puts her as a shareholder. Maybe she was thinking about her husband at the time, her boyfriend at the time. There could have been many, many other things that she was thinking about. And all she had to think about the whole time was what is in the best interest of the company. Is that clear, Dee?
Can I just make a comment? So the big issue that comes up is where you are a shareholder rep. And you would typically get instructed in terms of how you need to vote.
You shouldn't be instructed, by the way, but go ahead.
That's what happens in practice, because the shareholder will appoint you and they say, well, this is actually what we're trying to achieve. Even if it's not implicitly stated, you can pick up what, you can read between the lines. So what would your advice be? Because for me, I've always had this notion to say you need to manage expectations with the person appointing you on that board to say,
that's one
just
way.
understand that you're appointing me on this board, but I will be acting in this manner, and kind of stick to that. But in practice, it's difficult to actually. So what advice or what other insights do you have around that?
I don't want to sound like I am ignorant of the pressure that people have as people, I'm appointed by this shareholder, I must, speak for them. The Companies Act doesn't care who appointed you. The Company Act doesn't care that only is a most senior board member. It doesn't care. The Company Act says you yourself as a board member, these are the things that you have to comply with in order for you to execute your fiduciary duties, you know? Maybe because you're a shareholder appointee, you upset them, they're angry with you, and maybe they fire you. You know what? I'd rather you get fired for that reason than staying on the board and doing what Dudumeni did. Go ahead.
I have another question from online.
Yeah.
Lots of hearts coming through, by the way, and lots of people loving what you say. Yes,
okay,
the emojis. You're getting lots of emojis. Thank you very much for your comments and reminding us of the North Star. I'm interested, and this comes from Yeti. I'm interested in your view on how one balances the best interest of the company, which is part of a group, when one sits on the board of a company and the board of the holding company.
I've seen those scenarios quite a bit. So if you're sitting on, I think the question is you're sitting on both, right? Yeah. So oftentimes you find that happily, the best interest of the holding company is the best interest of the subsidiary. Oftentimes that happens, but oftentimes it doesn't happen. So you insulate yourself. You're sitting in the board meeting of the holding company. It's almost as if you forget that you sit on the subsidiary. You make a decision in relation to what you are seized with at that moment, and it's put before you at that moment. You make the decision in relation to that company because that's where you're sitting, and that's where your obligations extend to. Tomorrow morning, you go to the subsidiary, and you are sitting in the board meeting of the subsidiary, and you are finding out for yourself whether or not the decision that you made in relation to the holding company, in fact, is in the best interest of the subsidiary. But they are all independent inquiries because you yourself are put in those positions independently, so to speak, as a board member.
As a follow-on, the use of information in making decisions.
Yes.
When you're in the one board meeting, then how can you share or can you share information with the holding company board? Only
to the extent that that information was disclosed to you for that proper purpose. Remember, we spoke about proper purpose. So you cannot use information that you gained in your position as a director in the holding company to gain advantage for yourself, personally, or your friend, or Oli, or whoever, in the subsidiary. It must always be for a proper purpose. And that proper purpose has, oftentimes, when you've met the provisions of 76.3 and 76.4, you've done all that needs to be done for you to say, I have acted appropriately in relation to that particular company. So you will find, and it often happens, and it often happens in relation to holding and subsidiary where information is shared across the different companies. So you would receive information from the holding company and you receive exactly the same information from the subsidiary. So there is actually no danger in you saying, oh, I'm disclosing secrets from the holding company because you probably have the same information. And a very good example is where you have the holding company holding 66% in the subsidiary, for instance, and I don't know, the subsidiary needs recapitalization, for instance. The holding company would be making a huge profit, but for this recapitalization. You know what I'm saying? You're smiling, you probably know what I'm talking about. You still have to make the decision in respect of each company, what is in the best interest of that company. Yeah?
I just want to follow up on something Judith said. I mean, let's take the case of Mam Dudu Yeni. You are asked to do something that goes against everything that you have outlined here, right? And you take the decision that you're going to resign, you're going to walk away.
Yep.
However, while you were there, certain decisions were taken, right? Yeah. That you had you went along with it while you were figuring out
your imprimatur. Yeah.
So I suppose the question is, in a country like when you're on a public entity board, like, SAA was, really, how do you just resign and walk away knowing that things are wrong in there and that it's going to go where it's going to go? Or is there something else you should be doing as somebody who is accountable, responsible? And also, what's your liability on the decisions before you walked away?
When you made those decisions and you were a director, you are liable. You're personally liable. So just because you suddenly have a conscience, then you walk away, that doesn't mean the decisions that you are complicit in disappear. You are held liable. The Companies Act is not asking you to perform miracles. And it's not asking you to go and get a PhD about what it is that your responsibility is in terms of, I must now study what the duty of care says. No, it doesn't ask you that. It's actually asking you to act as a reasonable person in the position of a director of that company. So you cannot now suddenly, and maybe actually in the beginning when you were making those decisions, there was some benefit to you, people liked you more, or whatever it may be. And you know what? I'm not undermining how it feels to be liked. I like being liked too. But if being liked means that you're compromising yourself and your reputation, but also more importantly, you're breaching the laws, there's no point to it, right? So you've got to do. Think about yourself as a captain of the ship at all times. You don't have to be the chairperson of the board to make those decisions. You are there. The Company Act treats you exactly the same as directors. Each one of you carries those fiduciary duties. Each one of you carries those statutory duties. So you can't pander to somebody else. I can't say, Polly said I mustn't say this. It cannot work that way. That's why you have the Companies Act, and I suppose all other laws that we have in the country. Was there another question? I saw the mic roving. Yes, ma'am.
Thanks. Hi, I'm Mami Dupi. Maybe just two questions. The one, I think, holding company boards and shareholder boards are always tricky, especially with this conflict story. The question of dividends is always where, the issues always come into play.
Mm-hmm.
And for me, I guess, as much as you can tick the boxes and say I'm acting in the best interest of the subsidiary that I'm sitting on,
mm-hmm.
there's always this piece of information that the primary purpose of my divvy is to fund something else that's happening at holdco level.
Mm-hmm.
And so how do you deal with that? Because as much as you can be at peace for acting in the best interest of subsidiary, the primary reason for that divvy is because you're funding some other transaction
mm-hmm.
at holdco level.
Mm-hmm.
And, maybe just your advice around that.
Mm-hmm.
And then I'd be interested in your views on, if you can, the Barloworld situation. I guess it talks to your Toli situation, because again, I come from the private equity world where you want management to be involved in the transaction from an alignment perspective. It's also not practical that management is removed from the business
mm-hmm.
because from a stability perspective.
Mm-hmm.
And I guess the disclosures are there, but how do you deal with that? I guess I don't know what's happening at Barloworld, but the noise is that he should have removed himself.
Yeah.
Is it practical? How do you deal with that?
Yeah. I'm a little bit concerned that maybe this is coming through properly, and I'm just going to repeat. I'm going to repeat myself. You walk into a room, you've been appointed, you are a board member. Okay, let's leave the names out. You're a board member. The first thing that you think about, I use it as a North Star. Your North Star is every decision, whatever it may be. I'm not talking about are they buying tea or coffee? No. Every decision that has to do with the operations of that company. Every time you're seized with, sorry, your name is? Mami Dupi, you have to make this decision. Mami Dupi, you have to ask yourself, look yourself in the mirror if you have to. Is this decision that I'm about to make in the best interest of the company? Because already you've read the package and you've made notes in your board pack and so on. And maybe you are conflicted. And maybe actually you don't want the dividend to recapitalize the subsidiary. Whatever it is. Even if in that case, your interests are against, your own personal interests are against what you believe to be in the best interest of the company. You have to go against your own interest. And I used a very good example of where I told, the chairperson of the board, if you're going to go along with the decision, you're going to overhaul the decision we made, and we're talking about a listed company. Your name is out there, your reputation is out there. If you're going to make this decision just because you can, just because you're the chairperson, just because Makulu boss, as they say, I am going to recuse myself from this board and leave. You have to be that definitive about where you stand in relation to your obligations. They are not, am I wearing blue jeans or black jeans? They are not that, they're not feeble like that. They are serious decisions that you have to make for yourself. you are sitting there, you're thinking, hey, you know what, this decision is going to deplete the dividend, or actually we might not be able to get an increase. A very good example, we might not be able to get an increase as board members, or we are told, no, we're going to give you a 4% increase, but CPI is at 8%. It irritates you. It's annoying, right? Because you're sitting there, you're thinking, I had already planned to go overseas, or I had already planned to buy that new bag or whatever. Now I'm getting less than what I had planned for. It's annoying. I know, I understand that. And I'm not saying I'm not a human being. I understand all of those things. You still come back to the same question. You're North Star. If I shake you in the middle of your sleep and you're dreaming, I say, as a board member, what must you ask yourself? You must wake up and say, what is in the best interest of the company? Forget about your own personal interests. Forget about the CFO, forget about the chef, forget about all of those other people, because all of those people is just noise, right? In your own personal circumstances, you're always thinking, what is in the interest of the company? And this is what I was saying about how in the Dudu Mieni matter, the late Madam Mieni made all these decisions that she made. I mean, if you read all of the decisions, all of the cases that came after her matter was settled, every time when you read about what she said or what she did, it had nothing to do with the company. Every time you read, I was reading in trying to prepare for this, I was reading all the different cases. Every time she made a decision, it had nothing to do with the best interest of the company. There was an example, there was one of the cases where they had to go to France, I think it was, and collect one of the Airbus planes. Now, I know a little bit about this, as you would have picked up, because I was general counsel at SAA. So I know what it means when teams are saying there's a plane that is ready for us to go and pick up in France. And she said, no, I'm coming with. So everybody's like, no, they're probably very polite. Yeah, I'm going to go now. She's saying now it's time up now. Oh, no, but you don't have to be there. We have this person and that person who are authorized to do. She's like, I'm coming. I'm going with you. On the day, I think on the day or 3 hours before, she's like, no, I can't come. She calls them. She's wearing her dookie. She's probably sleeping. She's like, I'm not coming. Do you know what I'm talking about? Yeah. So, Mamidi, you should never, ever find yourself in that position. Because truly, if nothing else sways you, you have to think about your own reputation, because you take yourself with you. I'm going to be quick. Dee, I know, Dee. Hey, Dee is looking at me. She's giving me that eye. She's giving me that eye that she used to give me when we were 12 at high school. I've already spoken about all of these obligations, the fiduciary duties, and how I broke them down. And then suddenly you are filled with this anxiety that, the director liability is so high, maybe I should never be a member of the board because, this is heavy, I can't deal with it. But actually you don't have to have that anxiety, because the legislation we've all agreed, section 76 and 76.3 and 4, give you that protection, that safe harbor to operate in that space in a manner that you are always constantly allowed to charge for yourself, whether you're acting in the best interest of the company, whether you are exercising a duty of care, whether you're acting diligently, et cetera, et cetera. So very quickly, I was going to say, if you fail under all of those provisions, let's just say you were like Mam Dudumien, you just fail, right? You have to realize that then in terms of 77.1 and 2, you are personally liable. Personally, we're not talking as a group of directors. Personally, me, Happy Masondo, who's not related to the mayor, I am personally liable, right? And your liability extends to any loss that is incurred, any damage that is suffered by the company, any costs. If we're talking costs, it could be direct, indirect damages, consequential damages. That's huge, right? And also when you have failed to disclose 75.5, when you fail to make the disclosure that I have an interest in this, and I'm declaring that because of the interest, then there might be a conflict of interest. Also, more importantly, section 76.2a, somebody asked about the information that you get at different levels. You cannot use information obtained in your position as a director for your own benefit, Or you go and you call Polly, your friend, hey, by the way, this is going on there, buy the shares, that type of thing. You cannot do that, all right? You cannot, already have said, you cannot breach any of the fiduciary duties. We've spoken about that. And you cannot act outside of your duty to act with authority. So you can't go out and call Polly and, talk about what's going on at the board level outside of the due authority that is given to you by the company. Very, very, very quickly, in the case of Veneta, which you'll see at the bottom of page 6, I think it is, that in that case, the Supreme Court of Appeal pointed out the facts very, very quickly was they were trying to hold directors liable for what was owed to the creditors. And unfortunately for them, they obviously didn't have Polly as a lawyer because they misplaced themselves. They used Section 218 and Section 22 as a basis upon which those directors should be held liable. And the Supreme Court of Appeal, some of you will know, it's the highest court in relation to these types of matters, said, so what you find in Section 22.1, I urge you to all go and read it, and Section 218, it's not wholesale liability, It's not, and they were specific to say, if Sections 22 and Section 218 were treated as wholesale liability, then none of us would be board members because we would all be worried about, little thing, you are suddenly liable. Little thing, you are suddenly liable. So that's an important part about that case. How much more time do I have, or do I not have time at all? Zero. When they get around to sharing the presentation, the last part, I've got 3 cases there that I encourage you to just have a look at. The Humisa case, the De Bruyn case, and the Veneta case, all of which are talking about our legislatures never intended for 22.1 and 218 to be wholesale liability, because in fact, it would go against the spirit of having members of board, because then people would be worried about just how much liability they should carry. Thank you, everybody. I hope.
Thank you very much, Happy. It was very insightful.